Well, thanks everyone for having me today. It's really an honor to be here as you start this journey to talk about, where do you want to go next with the Michigan sentencing guidelines, I think I really appreciate being asked to be here today. If you paid attention to the bio, which was too long, you will have heard that I've both served as the chair of the Minnesota Commission and also as its executive director in the past. So I've had experience from both sides trying to figure out how to staff that group, what information they needed, what would be useful as the commission did its work, and also trying to lead that commission in terms of policy change. And so today, really what I've been asked to do here today is to talk to you primarily about what the goals of a commission are and what the importance is of having a sentencing commission within your state. But I'm also going to take podium privilege to talk a little bit about how Michigan's guidelines differ from other systems across the country. Because at the Robina Institute, we're actually the only institute in the nation that has expertise on all guideline systems across the country. So I have that understanding comparatively of how your guidelines work compared to other systems. Although I will say, I don't know if anybody knows how your guidelines work because they are the most complex guidelines that exist. Maybe with the exception of the federal guidelines. So you two are 1 and 2 in terms of complexity, but that's okay. We'll figure it out. So these are the 2 things I'll talk about today. All right, so there's really 2 types of sentencing commissions across the country. The first type really is the old guard type, which is what Minnesota was. The commission that was formed to embark on this new exercise of developing sentencing guidelines commissions, and then developing sentencing guidelines, and then monitoring, reviewing them, keeping them up to date. So the Minnesota Commission was formed 40 years ago. We had the first set of guidelines that were enacted in the country. There were several other commissions that came to life during that era as well. In the 2000s, the commissions that began to crop up were more brought forward to develop policy solutions for states. So a lot of the newer commissions tend to be broader based, and they work sometimes on sentencing guidelines and sometimes on all criminal justice issues within the state. So those are the 2 kinds. And if we look at this chart up here, the states that are in dark blue have both a commission and sentencing guidelines. The states that are in the mid-range have sentencing commissions but no guidelines, so they tend to just work on criminal justice policy recommendations for the states. And then the 4 states that are light blue are the states that started out with guidelines and a commission, and somewhere along the way their commission fell off and went out of business, but the guidelines remain in the system. I'd say that Tennessee is sort of the one state that it's a bit of a stretch to say that they're a guideline system. They have the guidelines embedded in their legislative code, but there's really no one's been minding the store since about 1994. So it's become just the underlying structure for sentencing that the legislature now controls with regular updates. Missouri's commission fell away just a few years ago. They're actually trying to get that restarted again as well. The situation in Michigan and in Florida, it's really the Department of Corrections that's kept their guidelines going because they're continuing to monitor and track data. So you can actually see what's going on in Florida because the data is there to see it, but there's no body at the helm trying to help control policy in that state or to help adjust the guidelines as needed. So that's sort of the state of play. We're going to focus on the dark blue states there as I continue to talk about guideline systems. Sorry, there's a little bit of a delay, so there we go. All right, so guidelines commissions can be placed in any branch of government, really doesn't matter. Most are an independent agency within the executive branch, but several are also located within the judicial branch or the legislative branch. And really, what's more important is that the agency be independent and that it have staff to support their work. So where they're located is not as important as how they're structured. Whoops, oh, see? He told me there'd be a delay, but did I listen? No. All right, so here's the commission sizes can range across the systems. So you'll see the Federal Sentencing Commission has 7 members, whereas the North Carolina Sentencing Commission has 28 members. And, you know, there's no magic number as to who needs to be included on a commission. It's really all about how inclusive do you need that group to be. The larger sizes tend to be associated with commissions that have a larger role in criminal justice policy because they're trying to be more inclusive of all the voices that need to be heard to set criminal justice policy in the state. So Utah is an example of that, where they have, you know, quite a variety of members. I would say just don't copy the feds because they only have 7 members. They didn't even include a defense attorney on their commission. So it's a very unbalanced view. It's actually located within the judicial branch, and most of the members are actually judges on that particular commission. There's nothing wrong with that, but it's like they have judges, they have a prosecutor, they don't have a defense attorney. So it's a little unbalanced in that way. The commissions that are in the middle probably have a little bit more balance in terms of membership. So here's the type of people that tend to be on sentencing commissions. Judges and prosecutors are on just about every commission that's out there. Defense attorneys, you know, all the sort of usual suspects that you would figure are on most commissions. It gets a little interesting when you look at, you know, only about half of the commissions that are active today have law enforcement or victims advocate members. Only about half have members of the public, and only about half have members of the legislature. I find the legislator members line particularly interesting. We don't have legislators on our commission in Minnesota, and we actually struggle sometimes where we've had very detailed conversations at the commission level of, you know, what's going on in this area, and then we have this huge re-education process, you know, when we try to bring that topic to the legislature, whereas in Pennsylvania, they have legislators on their commission, and so it's kind of already built in. They've been, that line of communication with the legislature is open right from the beginning. So if I were to sort of recommend any group in this list to make sure you have, if you want to change policy within the state, that's the group I would recommend. And then of course, I think actually all of the others above it are essential: public victims, public defense, corrections officials. I would actually add probation to that list because a lot of our sentences are probation. You know, defense attorneys, prosecutors, judges, all the usual players there. Commission staff size is also really important to think about, and as you can see from this chart, it varies a lot across the country. The commissions that are listed with bullets actually don't have any staff members dedicated to them and tend to be and are supported by some other agency within the state. And the commissions that have only 2 members, you know, those are going to be commissions that tend to really only focus on policy. You know, what should the policy of the sentencing guidelines be? And that's because with 2 people, that's about all that you can do, is try to develop agendas for the commission, try to do the research that's necessary. Some of those states do have other agencies within the state that might provide some support in terms of data analysis, but the trouble with having that sort of dual responsibility there is that if it's not within your agency, then you don't control what the staff does, right? So you don't control the priority of whether or not the commission is going to be able to get that data analysis when they need it. So the commissions that are at least a little bit bigger 5, 6, 7, 10 members, or 10 staff members, usually have researchers on staff who can collect data and help the commission put that information in front of the commission, so the commission can be doing data-driven kind of decision-making, understanding how are the guidelines actually working in practice, where are the issues coming up. If we're seeing weird sentencing patterns somewhere, they can kind of look under the hood and try to figure out which factors might be contributing to that. So, and on the other end, I didn't put the outlier on this that's not showing is that the federal system has about 100 employees. So that might be a little extreme, but maybe more than 2 would be effective. Okay, sorry. So these are, most commissions as yours. Oops, thank you. I'm never going to get this down, I think. Can you push it to the next slide? Oh, I went like way back. Next one. There we go. That's fine. We'll just leave it there. Okay, so here in Michigan, this is true as well when you did have a commission. But most commissions, when they are created by the legislature, there's some sort of enabling statute that sets forth what the responsibilities of that commission are and what sorts of things they should be doing. And it runs the gamut from developing those guidelines in the first place to collecting data, analyzing it, understanding it, creating projections for prison populations, understanding the effect of the guidelines, in other words, on your correctional capacity, your correctional resources, and maybe even developing racial impact assessments of your policies. So the whole list here is sort of, if you take all of those enabling statutes and distill them down to the main priorities of commissions, the whole list here is what comes up across the majority of systems. There's other things randomly that commissions are asked to do, but this is sort of the core of what most commissions do. And the 4 that I've circled are what I consider to be really the absolute core of what commission work is. So what I'm going to do over the next couple of slides is to take each one in turn and talk about what a commission can do within that bucket and what that can do for your state. All right. Let's see if this is working. Okay. All right, so most commissions that are, so the first one is collect, I'm actually, okay, back up one step. The top one was develop guidelines. I'm going to talk about that last. I'm going to talk about the other things first, the more administrative type work of the commission. Then we'll talk about development of guidelines, and then that's where I'll get into a little bit about what I see as being unique about your guidelines compared to other systems. All right, so if we talk first about collecting and analyzing data, most commissions do find a way to collect data regularly on all the sentences that are pronounced within the state. Most start on paper, right? Like the sentencing order gets sent to the commission, and there's somebody there who's pulling data elements off that piece of paper and creating a database. Hopefully, eventually you get to a place where that data is being sent automatically, through a computer feed to the commission, and it's just filling up their database. And the longer you do that over time, the more you can do with that information. And you can use that data to both get to a granular understanding of what's going on with sentencing and also an overtime trend line understanding of what's going on with sentencing. So here's an example of the more granular type of data that you might be able to understand. So this is part of an annual report that's produced by the Maryland Sentencing Commission. And this is a report that's showing sentencing for some of their main person offenses. So the first line that's up there, hopefully you can see, is assault in the second degree. Assault in the second degree for them. And so one thing that they can tell if you look at the underlying data, they can tell what percentage of these cases are actually following the guidelines when they're being sentenced. So it's about, it's too small on my thing. Is it about 70% up there? 65? Someone yell out. 65, 70, what is it? Oh, 85. Okay, see, I can't see from here. So 85% of the sentences for assault in the second degree are within the presumptive guidelines range. The boxes next to that show how many are mitigated sentences, so lower than the presumptive guidelines, and what percent are higher than that. They can also, in Maryland, tell what are the actual sentences that are meted out for this. So the first line there is like, what's the average sentence that a person is actually getting for this offense? And then next to that, what's the average sentence, the average time they're serving when you take into account any stayed time that might have been pronounced. So Maryland gets very detailed in terms of what sentencing really looks like, offense by offense by offense. They can actually give you that level of information. This is the kind of trend line information that you can get. So this is from Minnesota. This is a graph from the reports of the legislature that we just gave in Minnesota, and this is showing incarceration rates, right? So in Minnesota, we consider incarceration to be both who went to prison and also who received some sort of jail time along with a probation sentence. So the dark blue line at the very top is what's the incarceration rate overall for everybody who was sentenced for a felony. And we can see the trend line all the way from 1982 to today. And then the green line there is what's the conditional confinement, what jail time was somebody ordered to serve along, what percentage of people got a jail sentence along with their probation sentence. So we can see the trend line is pretty similar there to the overall trend line because most people in Minnesota get probation. And then the light blue at the bottom is the imprisonment rate. And we can see all the way back to 1982 what percentage of people received an imprisonment rate. And you can see that we've kept it fairly steady throughout that period of time. The dotted line is showing, well, if you look at what the sentence should have been under the guidelines, how many people should have received, or what's the proportion of people that should have received prison. And you can see that the guidelines policy is pushing the prison rate up, but the judges, the court, is keeping the imprisonment rate down, sort of at an even rate, because that gap is getting a little bit wider there. So we're actually, that little jaunt up at the very end, we are concerned about that as a commission right now because we don't know what's causing that. We know what's caused some of the other little jumps up. We had legislation that passed that called for more incarceration, so we expected that number to go up. But all of a sudden in the last 2 years, it's gone up and we haven't done anything. So now we're trying to look under the hood to figure that out. We think it's criminal history that's actually driving that, but we're not sure. So we actually have a team working on trying to figure that out right now. But that is what we can do as a sentencing commission. We can actually pay attention to what those trends are and figure them out. This is the demographics of the people who've been convicted of a felony in Minnesota, going all the way back to 1981 when the guidelines were first enacted. And so the big dark blue section of this chart, those are people who are white within that population. The green section are people who are black. Blue is people who are Native American. And there's a couple of areas on here where we can see major shifts in the policy or in the demographics. I want to try to get them all to come up. It's not clicking. Can you click it 2 more times? Perfect. All right, so we can see in the 90s, the proportion of people who were black started to increase greatly. That was actually when our drug laws were enacted, right? So we had a big shift in who was being convicted for felony offenses. you can see in the early 2000s, there's a bump up in the proportion of people who were white. That was when we first enacted felony DWI, and those are more often committed by people who are white. So the proportion of people who were white went up during that time. More concerning is the proportion of people who are Native American more recently has actually started to shift quite a bit. It's getting really large. For Minnesota, the Native American population is 1% of our population, but you can see that they are several percentages of our total felony population. So that is an area where we are greatly concerned right now, and we're trying to figure out what is causing that shift to see if there's any policy recommendations that we could make that might bring that population down to something closer to their proportion within the population within the state. But if we didn't have this data over time, if we weren't looking at it by demographics, we wouldn't know any of this. We wouldn't have had an opportunity to check and figure out what was going on anywhere with this. But right now, racial equity is a priority within our state. So we're really trying to work on all of those numbers and get them closer to mirror the population more closely. All right, so that was what a commission can do if you're with data. If you collect and analyze sentencing data, all kinds of things that you can do. The other thing that a lot of commissions are tasked with doing, and our commission is as well, is helping the state project the prison population so that you can actually figure out what resources you need, and also, what priority do you want to place on those resources as well. So this is the prison population projection in a recent report from the Kansas Sentencing Commission. You can see 2020 was a really weird year for everybody. So obviously their prison population fell like everybody else's. But so the blue part of the line is the actual prison population. The orange part is what they're projecting the population to be. So number one, you can just simply use the information if you have certainty in sentencing that's brought on by the guidelines. I'll talk about that a little bit more later. If you have certainty in sentencing and you have an idea of how long people are actually going to serve, then you have this ability to figure out what your churn rate's going to be in the prison and how policy is going to affect that overall population. In Kansas, there's also Kansas is also required to do an assessment every year to figure out if their system is going to get to the point of reaching or exceeding prison capacity. And if they are, then that commission is specifically tasked with bringing to the legislature ideas for bringing that capacity back down. How do we get back in line with the capacity that we have? In Kansas, it's important to them that they're not in a position of building new prisons. So that's what they use their commission to help stay within the capacity that they have. I've had the privilege of going down there, and the way that commission works is that each fall, if they have that type of assessment and they know that they're in that situation, then they have a 2-day retreat. Their commission goes on a 2-day retreat, and they throw every idea they can, on the table, and they talk through it. They get presentations from experts to help them understand the implications of those changes, and they start to develop what are the ideas that we could send to the legislature to offset this change so that we can bring that capacity back in. And then they send them off, and sometimes the legislature passes those items, sometimes they don't, but there again, that's a commission that has legislators on it. So oftentimes, all that work they've done at that 2-day retreat is really useful, because when they get to the point of going into session, they do have really knowledgeable members of the legislature that can help explain some of the ideas to their counterparts. All right, so that's the produced correctional population forecast. The other idea is to use the data to actually look at the fiscal and racial impact of any policy changes. So this is both legislative policy changes and policy changes that the commission itself might make to the guidelines. So this is an example of a fiscal impact analysis. This is an example from Minnesota. In the past session, the Minnesota Legislature introduced a bill to change the offense that we would normally know as being a patron of prostitution or being a person who purchases sex. The legislature wanted to take that crime and move it over to a new crime called sex trafficking. And as they were doing that, they were going to add this to the definition of crimes of violence. They were going to subject repeat offenders to more severe punishments, and they were going to change the law so that judges could not do a downward departure on the sentence. So the specific way that they were going to constrain judicial discretion was that they were going to say if the sentence calls for prison, the judge cannot impose a probation sentence. So this is the projection that the commission made of, well, how many prison beds will that result in? In 2022 and 2023, really minimal, not very many. You go all the way out to the end, and it's about 18 prison beds per year from that year on. That would be the projection. And if you look at, whoops, went too far back. If you look at this section right here that I've circled very beautifully, what you'll see is that decision to constrain the judicial discretion so that they couldn't impose a probation sentence is where most of those beds would have come from. So really we can get specific on what part of the law change is going to result in prison beds. So the way it works in our state is that this information gets added to the spreadsheets for the committees that are trying to balance the budget for the criminal justice policy bill for that year. And our legislature has to cover both the near-term and the long-term costs, right? So near-term, it would have cost them nothing. Long-term, it would have started to cost them something. So they'd have to decide, can we cover that expense out in the future? Is it a priority for us? So sometimes when we see a bill that has a number of beds attached to it, the legislature will look at it and say, we can't afford that. We're not gonna, this isn't a good bill for us. We can't pay for that cost. We're not gonna build a new prison. We're not gonna add capacity somewhere, so we're not willing to cover it. Other times they'll say, no, we actually think that this bill is, this crime really merits those beds. So they'll come up with legislation somewhere else that will reduce beds, and that'll offset the change. So that's the kind of information that we can give the legislature so they can make those policy choices as they go. And I've seen both happen. I've seen a high fiscal note, kill a bill. I've also seen a high fiscal note result in bargaining so that something else that used to result in prison no longer does. This is an example of a racial impact that the commission might want to do. So same bill. As I mentioned, this particular table shows actually more than just racial impact. It shows what's the impact of that bill by gender, what's the impact of that bill by race, and also judicial district. I cut that off, but the first and second, that's the first two rows of all the judicial districts in the state. So we could actually tell where in the state would those beds come from. So what we're showing here is that of the 18 beds that were projected, they would all go to males, right? So no females would be sent to prison for this bill. But 16 of those beds would be for men who are Black. So there's a high racial impact for this particular bill. So the legislature would need to weigh that as well as they're thinking through whether this is a bill that they actually want to pass. As it turns out, the legislature kicked the can down the road and sent it to us at the commission for further evaluation to figure out, is this the way that we should be sentencing sex trafficking or not? So we'll be reporting back to them next year. All right, so now let's get to the big one. The big purpose of many commissions is to develop sentencing guidelines, monitor them, and review and revise as needed. So just to make sure everybody in the room understands what I mean by that. Sentencing guidelines are a set of standards that are generally put in place to establish rational and consistent sentencing practices within a particular jurisdiction. In most systems, the goals of the guidelines are to foster proportionality, secure public safety, reduce disparity, manage correctional capacity, achieve certainty in sentencing. So we went through a couple of those ideas already in terms of how the commission can help to achieve those goals. Sentencing guidelines are not top-level policy, they're mid-level policy, and they are policy, they're not case-level decisions. So the legislature's role in all of these systems is to define crimes and to set the maximum punishment for what those crimes should be. And so that's what they do. Down at the case level, judges impose sentences in individual level cases, and they should be taking individual level concerns into account when they set those sentences. In the middle there, what a sentencing commission and sentencing guidelines can do is take that top level policy and break it down so that we can understand when we're looking at a person with these types of characteristics who's committed this type of crime, what's an appropriate sentence for that case? Not individually, before you take in those into account, those individual characteristics that the judge should be thinking about. So it's a mid-level policy. It takes like that 20-year maximum sentence that might be on the books for assault, and it breaks it down so that you can say, well, if it's an assault that results in injury, it's this kind of punishment's appropriate. If it's an assault that is involving a weapon, maybe this level of punishment is appropriate. And also taking into account the criminal history of the individual. So this is what a more simple sentencing grid looks like, a little simpler than what you have here in Michigan. Most systems have only 1 to maybe 3 grids. I think here it's 9 or 11. 9? 9, yeah. And so what a little bit of a simpler system looks like, this is Minnesota's grid. And we had this grid, actually it was our only grid until 2006. Blakely actually caused us to break some of the sentences out onto a separate grid. But until 2006, we put everything on here. And the way that our grid works is that the horizontal, the up and down axis is the offense severity. So that's looking at taking all offenses pitted against each other. Where do they fall in terms of seriousness? With the least serious being at the bottom of the grid, the most serious being at the top of the grid. And then across the horizontal axis is our criminal history score. And so that's just breaking down that maximum sentence into other sentences that are more appropriate depending on the person's criminal history. And every system that has a criminal history score, it might be a number on the grid, but it's usually a composite of multiple factors. So that 1 or 0 represents not just a counting up of priors, but looking at those priors and maybe potentially adding some weights to them, potentially having decay factors in there so that certain crimes don't count after a certain period of time, considering whether to have juveniles crimes count at all, which not every system does. So there's a lot of policy that goes into what that criminal history score is. But unlike Michigan, there's usually not a lot of policy that goes into what the offense severity is. That is generally just a ranking decision that's made by the commission, and I'll talk about that a little bit more down the road. All right. Oh, and I'll just show you on our grid the way it works is that if the cross section of those 2 factors hits a shaded cell, that means that probation is the presumptive sentence. If it hits a white cell, then the prison is the presumptive sentence, and the numbers that are in the grid represent the presumptive duration. So the other sort of key concept in the development of sentencing guidelines is that they should be for the typical offense. So wherever you end up with on that grid should be sort of the average case. It's not the most egregious case that you might have heard about in the news. It's also not the least serious case that might be before you because of other factors that have gone on in that person's life. So it's typical. Pennsylvania calls it the heartland case. This is the sort of, looking at all the varieties of ways that crimes can be committed, this is sort of where it comes to on average. If there's situations within that case that require some sort of adjustment to that sentence, though, most systems also allow for that, and that's called a departure sentence. And so departures are appropriate either up or down when there are atypical circumstances in that case. All right, so what does it look like to monitor the application of the guidelines? So here's two ways you could do that. Again, I'm sorry, I'm falling back on Minnesota as an example here because it's easy to pull from our data report. But on the left, we have the pie chart, and that shows, what proportion of guidelines, of sentences of all felonies fell within the presumptive range on the guidelines each year. So you can see that that's the biggest part of the pie. 75%, or about 3/4 of cases, fell into that range. The other quarter of cases were some sort of a departure, and you can see for Minnesota, the dark blue are mitigated departures. So the majority of the departures in Minnesota are mitigated. There's a small slice for aggravated. That number used to be about 5%, but after Blakely and that progeny of cases, got a little harder to depart upward in Minnesota. So that number has come down a bit. On the right side, so this is high-level compliance. Like, we know that about 3/4 of cases fall within the guidelines. On the right side, we can look offense by offense to see what are the compliance rates for particular offenses. And this is a chart that we show where we show the sort of problem children of what's going on in sentencing in Minnesota. And for all of these offenses, the departure rate is at or above 50%. So that's a signal to the commission that there's something going on there, that one possibility is the system could be giving us a communication back that the guidelines that we've set don't make sense and that we need to relook at them and maybe bring them down. If all the departures are mitigated, then maybe that's a signal that the sentences are too harsh under the guidelines. Another thing that could be going on is there could be something about the way the statute is written that's problematic. So assault in the second degree is the first bar there. For that's assault with a deadly weapon in Minnesota. And in Minnesota, a deadly weapon is defined broadly. And in some cases, there's case law that shows that, a boxer's hands could be a deadly weapon. But a gun could also be a deadly weapon. So you can imagine that it's really hard to set the right sentence when you have that broad range of behavior that could constitute the same type of crime. So that's a situation where we actually have a problem with the statute, right? The guidelines can't set a sentence that will satisfy the field because the statute's written too broadly. There's other instances too where we have, some statutes that have mandatory minimums, but also a safety valve on them, and those tend to have high departure rates as well. So that's a communication to both of us, right? The guidelines say if there's a mandatory minimum, that overrides whatever sentence the guidelines would have imposed. The safety valve says you can ignore the mandatory minimum, and so in half the cases people are, and in half the cases people aren't. So there's a problem both ways. So that's what sort of knowing what these kinds of departure rates are can help us explore and understand and determine if we need to make a change, if we need to recommend that the legislature make a change, or if both of us need to change. Guidelines monitoring also means looking at your own policies to see how they play out. So not just all the other statutes that define criminal conduct, but the actual guidelines policies, which in some states exist outside of statute, in some states exist within the statutes. So here's an example from Maryland. In Maryland, they do include juvenile adjudications as part of the criminal history score. And so one year during their normal public comment period, somebody asked the commission to take a look at how juvenile adjudications were being scored, because they felt that there was some disparity occurring within that. So the commission decided to take that issue up. They started to look under the hood, and they found out the way that their juvenile point was working was that you would get a heavier weight to the point if the juvenile had been committed to the Department of Corrections, and a lighter weight if they hadn't. And what they found out is that that concept of commitment varied across the state. So in some places, committed to the Department of Corrections meant committed to a juvenile facility akin to incarceration, right? In other places, committed to the Department of Corrections just meant under their supervision. So some kids who really didn't have very serious juvenile crimes were getting the highest possible weight on that juvenile portion of the criminal history score. And when they looked at that by racial demographics, they found out that the kids who were Black were getting the short end of that stick more often. So they were more often getting those harsher versions of the penalty. So the commission decided to redesign their score so that it would be more equitably applied across the system. They took out that definition of commitment. They based it more on the offense that the juvenile committed, and they're hoping that that will sort of even things out. They just did that recently, so they haven't been able to evaluate the effect of the change yet, but they're really trying to minimize that disparate impact on kids who are Black. So that's another thing you can do, is look at your own policy. All right, so let's talk about a couple of the key decisions that commissions often make when they're developing sentencing guidelines. And so I'll talk about that in Michigan's context and how I see some things that happened here that are a little different than the way they were decided across other states. So the first item is, whether or not there is a parole, whether or not parole is continued in the state. Many states that created sentencing guidelines also at the same time decided to eliminate parole so that they would have more determinate sentencing. But that wasn't the case everywhere. About half of the systems retained parole, and about half of them eliminated parole at the same time. For this, just want you to notice that for the states where parole is retained, 4 of those states no longer have commissions, though. So the guidelines are not, I would argue, are not exerting as much of an influence in those states as they once did. For the other 9 states, 6 guidelines set the top of the range when a judge is pronouncing sentence. Only 3 set the minimum range, as Michigan does. That one state is Utah, and they just do something completely different. Their guidelines just help the parole board determine how long the sentence should be. So let me talk a little bit about what that means to have your guidelines set the minimum versus the maximum range. So if we take a 20-year statutory maximum sentence, let's assume that the court sets a 10-year sentence. First, let's talk about setting the max. If the court sets a 10-year sentence in a system where the guidelines set the maximum, then what that means is that the parole board no longer has discretion over those last 10 years, right? So setting the maximum sets not only sort of constrains the sentence, but also constrains the discretion of the parole board. The court under this system could also set the minimum sentence, and then the space between the min and the max would be the area that the parole board has discretion to determine release. In contrast, in a system where the court sets the minimum, like in Florida and Michigan, the stat max is still out there as the maximum. So the parole's discretion is that whole range from the minimum to the maximum. That's the difference in making that sort of a decision. Pennsylvania is the only other state that uses the guidelines to set the minimum, but when they've made that choice, they also put in place a rule that calibrates the maximum sentence to that minimum sentence. So the max is actually double the minimum there. So when the court sets the minimum in Pennsylvania, it also changes what that, how far out the maximum can go. So double the minimum is the max. The parole board does not have discretion over the rest of that time. It's not available to them. So that's sort of the difference in in that decision of how to use your guidelines to set the sentence. The parole discretion moves from that big zone down to just that distance between the minimum term and the maximum term. So now let's look at how the ranges work here and then how they interplay with that maximum sentence. So this is one of the rows on grid B for Michigan. And what you can see is that if we look at the ranges for just the bottom, don't even look at the habitual offender ranges yet, that they not only increase in duration as you go across the grid, they also increase in width as you go across the grid. So what that does is that means that judicial discretion for where to set the minimum term is actually getting wider as you move down the grid. So then if you try to apply that to this concept of the min versus the max, like I just mentioned, at the lowest criminal history score on the Michigan grid, what that means is the judge has this sort of narrow range within which they can set the minimum term, but the parole board has a lot of room to work in terms of determining what the actual sentence of that person will be, because they'll determine when they get out. And then when we get to the highest prior record score, the judge has a lot more room to work within, and the parole board has less room to work within, because now the judge is setting that number way far out there, but they have a lot of room to work within. The difference in Pennsylvania, the other state like you that has parole and guidelines and uses the guidelines to set a minimum term, is that in Pennsylvania, the ranges are pretty even as you go across the grid. Every single row you look at, the distance is about the same. That means that the judge's discretion is about the same width no matter where they sentence on the grid. So judicial discretion is fairly even across the board. And then when you look at, now when you add to that the fact that the minimum sets the maximum by the doubling rule, judicial discretion is still fairly narrow. The parole board's discretion is also still fairly narrow, but each sort of increases appropriately as the severity of the offense increases as well, or as the criminal history of the offender increases as well. The sort of net result of all of this is that in Michigan, you have a high degree of uncertainty in sentencing because of the fact that judges have these wide ranges within which they can set the minimum term, and the parole board has all the room in the world to work with because they work with the full stat max. And then that uncertainty is exacerbated when you think about how the habitual offender ranges just increase the time within which the judge has to work. Whereas in Pennsylvania, they can get to a fair degree of certainty in sentencing because the guidelines set the minimum and state law sets that maximum at double the minimum sentence. How am I doing on time? Do I need to wrap up? Okay. Felt like I was. All right, just a couple more concepts. So one other concept is real offense versus conviction offense sentencing. This is another policy area that all commissions have to grapple with when they think about how to set up their guidelines. So in a conviction offense system, what the four corners of that offense say in the in the law is what defines your sentence, right? So if the offense itself doesn't include a gun, even if there's an allegation in the case that a gun was used, if that's not the offense you're convicted of with a gun, then you're not going to be sentenced for an offense with a gun. So really, it's whatever is in that conviction offense that matters. And what this emphasizes is the importance of the criminal code, the importance of proving all elements of the offense without a reasonable doubt or beyond a reasonable doubt. In a real offense sentencing system, the sort of offense that you're convicted of is just the starting point, and other facts can be brought in, often proved by clear and convincing evidence, which is the lower standard, and they can affect the sentence. Most systems don't use that. So in 11 of the 15 guideline systems, the offense you're convicted of really drives the sentence. In only the other 4 do facts that are not part of the offense affect where the sentence falls within the guidelines and on the grids. So as an example of what that means, here again is, I showed you the Minnesota's grid before. It's not that we don't have offenses that have different elements in them. So if you look at our assault statute or you look at our burglary statute, of course we have multiple types of burglary, right? One of them might be burglary of a home with a person in it, burglary of a home with a person not in it. But each one of those is an offense that's defined in the statute. And if you want to convict somebody of burglary of a home when somebody is there, you better, that has to be the offense that they're actually charged with. You have to prove those elements, and you need to convict them of that offense in order to get that sentence. So you can see that we have burglary ranked at 3 different places because it's defined 3 different ways in our statutes, right? Same thing with theft. The amount of theft matters to the seriousness. And so that's ranked at 2 different places because the dollar amount changes depending on where it's ranked. So the commission did that work of looking at all the elements of the offenses and figuring out how things rank against each other. And like I said, for most of our existence, all of the offenses were on one grid. So we could tell how things ranked across the entire criminal code against each other up until 2006 when we pulled the sex offenses off. So when the commission does those ranking decisions, we're looking at what are the elements of the offense, what is the type and amount of harm, what is the statutory maximum punishment. All that goes into where the offense is ranked on the grid to begin with. Those are not factual decisions that have to be made in the court. So that's one thing that's unique about Michigan is a lot of those are factors that are coming into play at the time of sentencing here. Only 3 states allow additional facts to affect the offense seriousness. That's Alabama, Maryland, and Virginia. And in those states, it's pretty limited what they allow to change that, and it's primarily weapons use, victim injury, victim age. All right, and then the last topic I'll hit is enforceability. These are generally the factors that sort of help determine whether or not guideline systems are enforceable. One of them is requiring the court to state reasons for departure. So you can't just do it. You have to put on the record exactly why that departure is occurring. Second one is having not only state those reasons, but have a standard to measure that departure against. A lot of states use substantial and compelling circumstances. That's the word that should have been. Allowing appeals of guideline sentences. Some states allow appeals within the range. Often that's for error correction, but it can also allow for an argument such as you should have departed on this sentence because of these facts. Allowing appeals of departure sentences for both sides. So prosecution can appeal, so can the defense, and a lot of states allow both bases for departure, just a full appeal of the sentence regardless of which side you're on. And then regularly publishing reports is also a way to bring states into compliance with the guidelines. Pennsylvania is famous for this because they not only publish reports on how the guidelines are working, but they publish it by judge. And that's sort of a peer pressure way of getting judges to come into compliance in an advisory system where the guidelines are not mandatory. So this is sort of how the states all stack up. And I'll be honest, I cannot figure out how to classify Michigan or the feds because you have a lot of the elements, both systems have a lot of the elements that would make guidelines mandatory. But because both systems have been undercut by case law, they don't function the same way. These elements don't work very strongly in the systems anymore. At the federal level, I think we've all seen the reports that there's wide variation depending on what district you're sentenced in, whether or not they adhere to the guidelines. So it's really hard to classify these systems. Pennsylvania is an advisory system that leans mandatory because they use every single one of those tools to help keep the system in play. And that is it. As I mentioned, we are the only institute that's an expert on sentencing guidelines. We actually have a whole website. So if you want to go and look at other systems, you definitely can. And my contact information is there. I don't know if we have time for questions, but I'm happy to take any if we do. Okay, thanks. Any questions? I think so. I'm not in control of that, but I'm happy for them to be available, yes. Yeah. Go ahead. So the question is, do we know why the legislature made the ranges so wide? No. I mean, I honestly can't answer that. But I did look at, I did look at other guidelines to see, I only compared you on the screen to Pennsylvania because they're the ones that are most like you in operation. But I did look at other systems to see, do other systems ranges also get wider? And a few do, but not to the same degree that Michigan's do. So that sort of phenomenon of not only going up in duration and also getting a lot wider as you go down the row is pretty unique to Michigan. Yeah. So I'm not sure if everyone who's on Zoom could hear that, but the comment was made that there's a law in Michigan that the maximum or the minimum cannot be more than 2/3 of the statutory maximum sentence. And I did actually check that against the ranges, and it does look like at the far end that is what's setting those ranges at the far end of the grid. So the idea might have been that we start there and then work backwards. And that actually is a policy decision that many commissions have had to grapple with. So in a state like mine, where we put this maximum sentence, where the court pronounces the maximum sentence, we had to decide, does the statutory maximum go on the grid anywhere? Or is it okay to have something less than that, even at the highest criminal history score? And in our state, most offenses do not have the stat max on the grid. The exception is the sex offender grid, and that was a deliberate decision made to put the stat max out there on that grid when that was pulled out in 2006 after Blakely. So yeah, that is definitely a policy decision that commissions have to grapple with. Do we have to have that stat max on the grid, or are we comfortable having something lower than that available to the courts, knowing that if they really need to get up there, they also have departures that they could utilize to sort of get the rest of the way if they want to. All right, well, that's it for me. Thank you so much for having me again.